On July 26, 2025, officers responding to a bar disturbance made an arrest for battery and resisting arrest, both misdemeanor offenses under Florida law. This footage raises three distinct legal questions worth examining closely. First, was the arrest constitutionally sound? Second, was force proportionate? Third, did officers follow proper procedure before and after taking the subject into custody?
Time to go. Time to go.
Thank you. I got just standing there watching her. Go inside. Go inside.
We don't do anything, we're the problem. We do something, we're the problem. The fuck?
You're not the problem.
Let's go. You ain't home. Let's go. You ain't home. You ain't home.
Don't let me go no more.
You don't want to go to jail. Stop. Hey, get that shit back. Let this hoe out. Let her do it. You ain't doing nothing. She should never hit me. She hit me. I'm done. My hands are over. I'm done. No, she should never hit me. She should never hit me. I'm not going to let nobody hit me.
Listen, stop. I'm trying to stop her so nothing else happens. Was she the one hitting you earlier?
Yes.
Here.
Yes.
Okay.
Where's the other one?
She was originally hitting her first.
Huh?
Yeah. She's not going. She was defending herself.
Okay, so she's gone.
Yeah, she's going for a fray.
She won't give it to me.
Do you want to press charges for battery?
Yeah, I want to press charges. That hoe should never touch me. She must have my baby daddy or something.
All right, I need a sworn statement from you.
Come on, let me put my phone down. I gotta call you back because you. Okay.
You can stay on the phone.
No, I don't want to stay on the phone.
You better press charges. You better go to court.
I'm going to court. That hoe should never try to swing on me, hoe. I don't play like that.
Who checking? Because we're finna eat it.
That's ours.
Okay, can you raise your right hand for me? Miss
I'm
Pettis?
left-handed though.
Bitch,
It
raise
doesn't
your
matter.
hand.
Oh.
Everything you're about to say is the whole truth and nothing but the truth, so help you God. Yes? No?
Yes.
Okay. Can you tell me how this all started?
We was in the club and she said, Topanga, I know you. I said, girl, where you know me from? Oh, don't worry about that. I'm from Atlanta. I be in Miami. You need to take care of your kids. That hoe must know my baby daddy or something.
Okay. That's what she said to you?
Yeah.
You can put your right hand down.
Oh. She said, don't worry about that. You need to take care of your kids. I have 3 kids with my baby father. Me and him, we together, but
I'm sitting in the police car.
but we not. And I told him,
him.
I told her, please just leave me alone.
Yeah.
I said, please just leave me alone. So she started going out the club talking shit, and I started doing like this. So I could touch you like that.
Yeah.
I started doing like this to her. I said, please leave me the fuck alone. I'm telling
She's in
you.
your face, though?
Yeah, she in my. We like this. Me like me and you.
Inside the club, right?
Inside the bar.
Okay.
And I'm telling her, please leave me the fuck alone, girl. You don't know me.
Okay.
Don't worry about how I know you. My name is, it started with an R, from Penny Proud. The same name as the girl from Penny Proud. I said, I don't know you. And she said, well, hold on, worry about me. You take care of your kids. This is what she exactly did. And I told her, and I mushed at her. I said, please get out my face. And I started walking to the bar. And when I started walking to the bar, I'm sitting at the bar, and as the lady walking her out to the bar, she reached like this to punch me. So you already know what I did.
Okay, so you swung back in defense?
Yeah.
All right, so what happened out here?
Nothing. She was by the car and said, get the fuck out my face. She told that to Nisha. Nisha Reed. She said, get the fuck out my face. I said, Nisha, let's go, let's go. She said, nah, ho, cause what's up, Topanga? What's up, Topanga? And I, pop, right in her face.
She had her set up, though.
Yeah, she had her set up.
Is that when we broke you all up?
That's when we was right here by the handicap sign.
Okay.
When she swung on me.
Okay.
And then I had to...
What, and then her friend came back over here, and then she came back up to the front of the car, and that's when she started trying to fight you
She
again in
started
front of
trying
us?
to fight me in front of y'all. Like, you see
Okay.
the police right here. I'm not going to fight you in front of the police. I'm
Did she
scared
ever
of the police.
did she hit you in the face? Did she make contact with you?
No, just my arm.
So she punched you in the arm?
No, she punched me in my fucking neck arm.
Okay, and then you were fighting back in defense of yourself?
Yeah.
Okay, understood.
All right,
Anything else?
civilian. No, give me a
I
hug.
can't give you a hug. It's not professional. And my boss is here.
Boy, give me a hug.
Hey, that female we arrested, was she removed from the bar? Like, was she kicked out?
She was kicked out and then tried to get back in.
Trying to get to the other chick? Is that what that was going on?
Trying to get to the other chick, and then she was trying to get to her stuff. When her stuff was brought out here,
Okay.
she swung on the bartender.
Oh. Does the bartender want to press charges while she's under arrest?
Hold on.
Yeah.
Still security guard.
She said yes.
She wants to prosecute? All right.
Do you need her information?
I do.
Need her information?
Yeah, let me get my phone and stuff though. All right, so she was kicked out for trying to fight the bartender too.
Yeah.
Well, so this is what I got. She was in there. She tried to fight that chick over something petty. I don't know. Girl pushed her back. Bartender went to go escort her out. She swung on the bartender. Is what I understand. So she got kicked out, and then that's when they started fighting out
Started
here.
arguing out here. She started
All right. Thank you.
I would like to talk to you, please, sir. Officer, please let
Too
me...
late right there. We gave you many chances to fucking stop.
Sir, please.
No, you're going to jail.
Okay.
We gave you an ample amount of opportunity.
Sir, I'm not going to fight with you. You are the law. I'm not going to fight with you. Whatever you feel, unfortunately, I don't want to believe it. But if that's the case, that's so be.
Huh?
If that's the case, that's so be, sir. I don't want to beef with you. I'm not trying to fight with you or nothing. I don't know what's going on. I'm sorry. I've been drinking too much. But that's what it be. Sir, can you come open the door for me? I won't run. Please come open the door for me. Please!
Hey,
Please, you don't know me!
stop.
Please, let me open this door, please! You don't know me!
Pass that part.
Please! Open the door, please!
She slipping?
Please! Please! I'm a woman, please! 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 My mom is here, please! I promise I'll stop, but please, I'm right here. I'm right here with my mama. My mom! You don't know me, please! Please, my mom! 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 Mommy! Please, you don't know me. I never sold no drugs, no nothing. I'm just a black girl. Please. Please. I'm not resisting nothing. Please. I want to go home. Please. Mommy! Mommy! Mom! Mom, please! Mommy! Stay here. I won't do nothing to you, please. Just let me go home. Mommy! Mom, please! I didn't do nothing. I just want to go home.
I would think.
Please. Please.
Put your feet in the car.
I didn't do nothing, please.
Thank you.
How could you do this nigga to me? How could you do this to me as a woman? How could you do this?
I didn't do anything.
Yes, you did.
No, I
How could
didn't.
you do this to me? I didn't do nothing. I'm not trying to go to prison. Nothing. I gotta go home.
Can you pull your knees out?
You.
I'm just asking you to pull your knees out. Okay. Enough for me.
Now you really know.
Under Florida Statute Section 78403, battery is defined as the intentional touching or striking of another person against their will or intentionally causing bodily harm. The subject struck the victim in the neck and arm in the parking lot directly in front of officers. That single act, witnessed by law enforcement, established probable cause for arrest on the spot. Under the Supreme Court's ruling in Atwater v. City of Lago Vista, 532 U.S. 318, 2001, officers may lawfully arrest for a misdemeanor committed in their presence without a warrant. No gray area exists here. The arrest was legally authorized the moment contact occurred. The bartender's statement adds a second independent count of battery under the same statute. Each physical act against a separate victim constitutes a separate chargeable offense. The subject was not facing one battery count. She was facing at minimum 2, possibly 3. On the question of de-escalation, officers gave repeated verbal warnings before initiating arrest. One officer stated on camera, "We gave her an ample amount of opportunity." This is tactically and legally significant. De-escalation is not a legal requirement for misdemeanor arrests, but its application here demonstrates professional restraint. Graham v. Connor, 490 U.S. 38C6 1989, established the controlling standard for evaluating use of force. Objective reasonableness judged from the perspective of a reasonable officer on the scene, not with the benefit of 20/20 hindsight. Applying that standard, the subject was visibly intoxicated, had struck multiple people, ignored repeated dispersal orders, and continued to re-engage the victim in front of 6 officers. The physical control used to place her in the vehicle was minimal and proportionate to that threat profile. No weapons were deployed, no strikes were delivered, the force level remained within what tacticians classify as soft, empty-hand control, the lowest tier involving physical contact. Resisting arrest is addressed under Florida Statute Section 84302, obstruction or resistance of an officer without violence. The key threshold here is without violence. The subject refused to comply with commands and required multiple officers to assist with placement, but did not kick, bite, or actively assault officers during restraint. That distinction matters. Had she escalated to active physical resistance against officers, she would have faced Florida Statute Section 843.01, resisting with violence, a third-degree felony carrying up to 5 years. Person. The sworn statement taken from the victim at the scene follows standard field procedure for misdemeanor arrests. While informal, this on-scene affirmation serves a legal function. Documents the victim's affirmative consent to prosecute and corroborates officer observations, strengthening the probable cause record that will appear in the incident report. One procedural gap worth noting: Miranda warnings were not captured on footage at or immediately following arrest. Under Miranda v. Arizona, 384 U.S. 436, 1966, advisements are required prior to custodial interrogation, not at the moment of arrest itself. If no questioning occurs before booking, Miranda timing is not a violation here. However, the absence of that documentation in camera is a note for the incident report. The subject's statement, "I've been drinking too much," is a spontaneous voluntary admission. Because it was not made in response to officer questioning, it is admissible under existing precedent and could be used to establish her awareness of her own impairment.
Now you really.
The daughter was arrested, okay? She was starting a altercation at the bar over here, which escalated to it coming outside. And we were standing in the parking lot at the time, okay? And she attempted to fight a female who was trying to get away from her, okay? We gave her multiple commands to stop and just leave, go home, and not escalate it, okay? But she was extremely intoxicated and wouldn't listen to us. So she struck the female again as this female removed herself from her, all right? And she was taken to jail for battery and resisting.
She was very intoxicated.
Extremely.
Especially with like 6 of us just kind of hanging out in the parking lot right in front of us, so.
I mean, yeah, like he just said, there were 6 of us in the parking lot with all of our cars there. We gave her an ample amount of opportunity, honestly way more than we probably should have, to go home.
I just came up here with my daughter. We were together, and she dropped me off. And I told her, be careful. I'm looking at her location, and I see she's here.
Yeah.
And I kept calling and kept calling and kept calling. So she lives close to Gun Club. Okay. And I see, so where's her car?
It's probably in the parking lot still. I didn't know she had a car here. Yeah, she was with us, but she just got transported to the jail.
Oh my God, I wish you guys could have let, I know you got to do your job.
Well, we didn't even, she wasn't really much of She just kept saying she wanted to go home. There was no real. She was really drunk. She was really drunk. She got really drunk. She actually. So, this all started inside the bar. She's allegedly, we didn't witness this, swung on this girl inside the bar and hit her, which caused one of the bartenders to come around the corner and escort her out. While escorting her out, she punched one of the bartenders too.
Oh my God.
And then they were fighting at the door, which we didn't see. We just saw a little commotion. We walked over there, separated them. We were like, hey, it's time for you to go. To all
She
of
was
them.
the only one that got arrested, or
She was the only one. We gave
This
everyone.
girl has a good job. She is a smart girl. Like, what in the hell? She should have just literally, I told her, be careful, because I did not, as a parent, I didn't feel right about something. But she's 27 years old. I'll be 27 next month. So I couldn't really, I'm like, be careful.
At the end of the day, like I said, we gave her more than enough opportunity than we usually give somebody, seeing that she was extremely intoxicated, to go home. But she just insisted on keep trying to fight just once.
To be honest with you, I don't even think she saw us there.
Probably didn't.
I mean, we were sitting right at the front door.
I just wish somebody would have called me. I'm literally 7 minutes away. But like I said, I'm like just laying there, and something, just mother's intuition, I'm like, something's not right. Something's not right. And I'm looking at her location, it's here. And I start to come, I'm like, okay, she's just a few minutes away from the house. And as I'm seeing her location, and I keep calling, it's passing her house, and it's saying gun club. And I'm like, what the?
Yeah.
Girl, oh
So I don't know how it's gonna. She'll
be out in the morning.
She'll be out in the morning. She has. They probably won't be able to release her because of how intoxicated she was. So they might have to hold her until she sobers up a little bit. But she has. We gave her a court date.
Okay.
So, but she had.
She will be let go tomorrow, or she has to go
Yeah,
before a
yeah,
judge or anything.
If she doesn't get released, she'll probably go see the judge. But it's an OR charge. It's a misdemeanor.
Okay.
Now to the grades. The officers receive a B+. Where probable cause was clearly established, force remained at the minimum necessary level. De-escalation was applied well beyond what the situation legally required. Communication with family at scene was transparent, professional, and legally accurate. The grade falls short of an A because Miranda documentation was not visible on camera, and no interior bar footage was captured, leaving the first battery incident unrecorded. The subject receives a D. At least 2, arguably 3, independent acts of battery were committed in a single night against a patron, a bartender, and again against the victim in the parking lot. Each incident constitutes a separate charge. The cumulative exposure is significant. The subject also ignored multiple lawful dispersal orders from uniformed officers in plain view. The grade is not an F solely because she ceased physical resistance once in custody, preventing escalation to the more serious felony charge under Section 843.01. Before the outro, a few takeaways this footage makes clear. For law enforcement, extended de-escalation is a professional strength, but it requires consistent documentation. Every warning issued should be captured clearly on camera and logged in the report. That record protects officers in any subsequent civil claim. For the public, voluntary intoxication does not suspend criminal liability. Florida courts have consistently held that intoxication is a mitigating factor at sentencing, not a defense to the underlying conduct. The charge still attaches. And when officers issue a lawful dispersal order, the legally and tactically correct response, the person's always to comply first and dispute the legality through proper channels later. The outcome of criminal proceedings in this case remains unconfirmed at the time of analysis. Based on established law and the footage reviewed, any battery charge carries strong evidentiary support. The resisting charge is equally sound. Both are misdemeanors subject to OR release. Leave your analysis in the comments below. If this breakdown was useful, subscribe for more legal review soft law enforcement footage. Thank you for watching.